SwayamPrabha. Digital India. Educated India.
Well, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 25th lecture, which I am going to deliver before you. The today's topic of discussion is right to die with dignity and peace, euthanasia and mercy killing. So, in this lecture, I would like to highlight whether euthanasia or mercy killing is permitted in India and what is the role of Supreme Court with regard to mercy killing or euthanasia, and what are the view of different democratic countries about mercy killing or euthanasia, and what are constitutional provisions or is there any statute in India which talks about right to die. You see, you might be aware about Article 21 of the Indian Constitution. Article 21 of the Indian Constitution says that no person shall be deprived of his life or personal liberty except procedure established by law. Meaning thereby, every person has right to live with human dignity, and no person shall be deprived from his life or personal liberty except procedure established by law. It means that any person can be deprived from his life if he has breached the law. So, lawbreaker has no right, or lawbreaker who has committed crime, who has committed murder, has no right to live in this holy world. He also deserves to be hanged, to be awarded death penalty, because that right to live with human dignity is a fundamental right provided in Article 21 of the Indian Constitution to the innocent person, law abiding person, but a person who himself has breached the law, a person who himself has committed murder, murderer has no right to claim that precious right to live with human dignity. So, what inference can be drawn from this? Inference can be drawn that right to, even right to life is not absolute fundamental right, because this right to life is not absolute in all respect. Every person has right to live with human dignity, but that if a person who has committed murder has no right to live in this holy world, because section 302 of the Indian Penal Code IPC, which talks about punishment for murder, and in that section 302 IPC, it is specifically provided that a person who has committed murder shall be punished with life imprisonment or death sentence. So, you see this Article 21 which talks about right to life or personal liberty, in that provision it is specifically mentioned that this right to life, this is a precious right, every person can live with human dignity, but this is not absolute right. But the question is, a person who is suffering from chronic disease has lost his all hopes, medical science is not helping him, and that disease cannot be cured in medical science. that disease is incurable. So, in that case, whether that person should be allowed to die, that person should be given euthanasia, mercy killing, particularly a person, a sick person who is poor, cannot afford the huge amount of his medical expense, and family has decided that they cannot afford medical expenses. In that case, the question is whether that sick person should be allowed to die. If he or she is on ventilator, so doctor should be allowed to remove ventilator. So, all these have been in debate for the last few years, and particularly the matter came before Supreme Court for its consideration in Aruna Shahbag case. I will discuss one by one, but before that I would like to highlight some statutory provision, constitutional provision and international convention, international instrument. What is the international approach, international law on this point? So, for that I have chosen this topic so that I can give entire information to you. You just can see on your screen. Article 3 UDHR 1948, which talks about right to life. You can correlate Article 21 with Article 3 of UDHR. Article 3 of the Universal Declaration of Human Rights 1948 is very close to Article 21 of the Indian Constitution. Our constitution makers were very much aware about this UDHR 1948. So, deliberately they put that human right as fundamental right under Article 21 of the Indian Constitution. Right to live with human dignity is a human right. Whether right to life also include right to die, this is the question, and this is the focal point of my discussion, that whether right to life also include right to die, and person should be allowed to, person should have liberty to die. And country like India, where people are unemployed, due to unemployment, if any person is willing to finish his life, he should be allowed. All these things will be discussed in detail, but before I discuss the social factors, I would like to highlight two important judicial pronouncement of Supreme Court, wherein Supreme Court has recognized this. You just can see these two judicial pronouncement on your screen. P. Ratinam versus Union of India and Gyan Kaur versus State of Punjab, EIR 1996 Supreme Court. What happened in P. Ratinam versus Union of India 1994? You will be surprised to know the case which I am going to discuss, P. Ratinam versus Union of India, EIR 1994 Supreme Court. Right to life also include right to die, and section 309 of the Indian Penal Code, which makes suicide as an offence, is violation of Article 21 of, hence it is unconstitutional. Right to life does not include right to die. You see how Supreme Court overruled its decision in Gyan Kaur case 1996. Right to life does not include right to die, hence 309 IPC is constitutional. I have also, you see, with the help of these two cases, I will try to explain the legal impact on society, dowry death cases. Now, let us understand the philosophy of this Ratinam case, P. Ratinam versus Union of India, AIR 1994 Supreme Court. This is the first case wherein Supreme Court held that right to life also include right to die, and section 309 of the Indian Penal Code, which makes suicide attempt as an offence, it is violation of Article 21 of the Indian Constitution. That is why it is unconstitutional. The problem with this case is, in 1994 Supreme Court for the first time held that right to life also include right to die, and a person who had decided not to live in this holy world can finish his life. On the other hand, section 309 of the Indian Penal Code, where attempt to suicide is an offence, section 309 of the Indian Penal Code makes a person guilty who has made an attempt to commit suicide. That person who has made an attempt to commit suicide is a criminal in eye of Indian Penal Code 1860, and that suicide attempt is an offence under section 309. The logic behind section 309 of IPC is that no person can be allowed to finish his life, because ultimately it is the state which is the patria, parent patria. Because of that concept, state has to protect life and limb of its citizen. I have liberty to speak, but I do not have liberty to speak whatever I want, which is derogatory, which is defamatory. Though Constitution of India gives liberty to me to express my views, but I cannot express my view, my thought in such a way which is defamatory, derogatory. The word used by me which is degrading, which is defamatory, derogatory, at that very moment I would be not allowed to speak. That means I cannot enjoy that liberty up to that extent. Similarly, I have right to live with human dignity, but I cannot finish my life. No person can finish his life, because ultimately it is the state which has to protect life or limb of its citizen. So, for that purpose section 309 IPC was enacted, inserted in the Indian Penal Code. So, in 1994 what happened? In P. Ratinam versus Union of India case, Supreme Court said that right to life also include right to die, and a person who is compelled to live in all adversities, it would be violation of Article 21, because no one can be compelled to live against his will. If he is not willing to live in this holy world and he had decided to finish his life, he should be allowed. What is wrong in that? So, this right to life also include right to die, and section 309 IPC was declared as unconstitutional. Can you imagine that a country like India, where dowry problem, dowry death cases were on rise, and in order to prevent dowry Dowry Prohibition Act was enacted in 1961. In order to have a tough law on dowry death, section 304B IPC section 304B was inserted in the Indian Penal Code. And if suppose if bride burning cases where a certificate is prepared, manipulated, fabricated by a husband or relatives of the husband just to convert a death, just to convert a murder in suicide, if they manage a document from a doctor that the deceased was suffering from mental disease, she had made several attempts to commit suicide even before the doctor. When she was brought before the doctor for medical treatment, she had made several attempts on several occasions to commit suicide. This is the certificate. She was suffering from mental disease for last 5 or 6 years. So, can you imagine that medical certificate would be helpful as a documentary evidence in establishing that case as a suicide case? Attempt is punishable, but suicide, a person who has committed suicide, who has succeeded in committing suicide, she is no more. So, attempt to suicide is an offence, but the completion of that act is no offence. So, abatement to suicide, that is an offence, but where husband or relatives of the husband, they have succeeded in establishing the fact before the court that the deceased committed suicide, she was suffering from mental disease, they have fabricated, manipulated document, they have managed document from the doctor. Doctor is also examined before the court, he has also stated the entire story before the court. So, can you imagine on the basis of that statement, right to life also include right to die. So, deceased who has finished his life, committed suicide, that is not an offence. So, what I have analyzed that bride burning cases or conversion of cases means converting a case from murder into suicide would have been very easy for the husband or relatives of the husband in case of dowry death, and section 304B would have lost its significance. So, considering the gravity of that matter, Supreme Court overruled its own decision in 1996. In Gyan Kaur versus State of Punjab, AIR 1996, just after 2 years of the judicial pronouncement, Supreme Court said no, it is wrong to lay down that right to life includes right to die, meaning thereby Supreme Court considered the gravity of its previous judgment delivered in P. Ratinam case and held that right to life does not include right to die. Right to life does not include right to die, and section 309 of the Indian Penal Code, which makes attempt to suicide as an offence, is constitutional. So, you see what what was the actual position of section 309 in between 94 to 96? It was eclipsed. Section 309 of the Indian Penal Code was eclipsed by the judgment of Supreme Court, and Supreme Court removed that eclipse. The Supreme Court removed that blanket which Supreme Court had covered in P. Ratinam versus Union of India case. So, after this judgment, no person is allowed to commit suicide, no person can finish his own life. So, you see, right to life does not means this right to life does not give liberty to any person to finish his life. And can you imagine the bright burning cases between these 2 years from 94 to 96? The entire society, the entire Indian society was in dilemma, and judgment delivered by the Supreme Court shall be binding on all courts within territory of India according to Article 141 of the Indian Constitution, that is a judicial precedent. So, district court, high courts, they were not in position to go beyond the decision of the Supreme Court, because Supreme Court had already held that right to life also include right to die. So, you see, trial court, knowing that the case which was brought before the trial court, it is against it appears that this is a case of suicide 309, but right to life also include right to die. Case is finished, trial court cannot go beyond that decision of the Supreme Court. If appeal is pending before the High Court was also. So, this with the help of these two judicial pronouncement, P. Ratinam versus Union of India AIR 1994, Gyan Kaur versus State of Punjab AIR 1996, with the help of these two judicial pronouncement, you must understand that what has been the view of Supreme Court with regard to right to life. Now, come to this right to die with dignity. Right to live with dignity, there is no doubt at all, this is fundamental right, but the question is, right to die with dignity is a fundamental right. This question came before the Supreme Court in the year of 2005. You can see on your screen, I have referred this case and facts also. What happened in 2005? In the year of 2005, Common Cause approached the Supreme Court under Article 32, praying that on March 9, praying that right to die with dignity should be covered under Article 21 of the Indian Constitution. On March 9, 2018, a 5-judge bench recognized right to die with dignity is a fundamental right. In Common Cause versus Union of India AIR 2018 Supreme Court, this is the first case, Common Cause versus Union of India, where Supreme Court for the first time held that right to die with dignity is a fundamental right, and Supreme Court also prescribed guidelines for terminally ill person. So, this is important case which I wanted to highlight. In Common Cause versus Union of India AIR 2018 Supreme Court held that right to life also include right to die with dignity, and Supreme Court issued certain guidelines for those people who are terminally ill. You might have heard one name, brain dead. A patient was being treated in any hospital, but he went in coma. That patient is on ventilator for 1 month, 2 months, 1 year, and the financial position of that family is not good. So, in that case, in case of brain dead, in case of terminally ill people who cannot be cured, so Supreme Court said that right to die with dignity should be allowed, and doctors at medical board should be at liberty to decide whether ventilator should be taken back or not. So, it would be up to the medical board. They are the right person who can decide whether patient should be kept on ventilator or not. In this way, Supreme Court for the first time recognized that right to die in peace, right to die with dignity is a fundamental right, essential component of right to life or personal liberty. Another important case which I would like to, this is a very leading case on euthanasia, mercy killing, euthanasia. You see what happened in this case, a petition for mercy killing was filed by a journalist on behalf of Aruna Shanbag, who was suffering from permanent vegetative state brain damage, brain dead. The facts are, in briefly I would like to highlight, I would like to discuss the facts of this case. In 1973, she was sexually assaulted by a ward boy, where she was working as a nurse. Aruna Shanbag, she was a nurse and working in a nursing home, and she was sexually assaulted by a ward boy. You see, the irony of law is she was brutally assaulted, but you see the irony of law is after 5 or 6 years the culprit was acquitted in the absence of the evidence, and he changed his name and he started working in Delhi, in a hospital situated in Delhi. But Aruna Shanbag, she was on ventilator, she went in coma, and she was put, a team of doctors decided to put her on ventilator. Since she was not in position to afford the medical expense, so it was decided by a journalist to file a petition before the Supreme Court that Aruna Shanbag, she should be allowed to die, and doctors should be allowed to put off to take back ventilator from Aruna Shanbag. But Supreme Court rejected the petition, and Supreme Court said that a medical team or doctor should be allowed to decide whether Aruna Shanbag, she should be kept on ventilator or not. So, medical, it is up to the medical board. So, you see, the considering the plight of that patient Aruna Shanbag, ultimately it was decided by medical board that since she was in vegetative state, it was a case of brain dead. So, doctors should be allowed to take back ventilator. The problem which I wanted to discuss in this case was, you see, it took a very long period to reach on that conclusion whether she should be, where mercy killing should be allowed or not, whether euthanasia should be allowed or not. So, Supreme Court for the first time made it clear that we should make a clear cut difference between active anesthesia and passive anesthesia. Active euthanasia is very close to killing of a person with deliberate, with intention. Active means assisting abatement in killing someone, abatement to kill somebody. Active euthanasia is allowed, it would be giving license to a doctor to take life of a patient. So, doctor is assisting in killing the patient, but passive anesthesia is where suffering from acute chronic disease which is incurable and has lost his life, he or she is on ventilator, then it would be better for that patient to allow him or her to die. But there should be a medical board, that medical board should take responsibility to decide the circumstances, to decide that when or at what time that ventilator should be take back. So, with the help of this slide I would like to discuss the guidelines on euthanasia 2018. You see, I have collected this material from living will has to be signed, that patient has, you see, the living deed you can see has to be signed by executor in presence of 2 attesting witnesses and counter signed by judicial magistrate. Now, the problem is, if the executor of will is admitted in a hospital and doctor certified that then matter must be sent to the district magistrate. You see, this is the rigorous procedure which is followed, sent to the district magistrate, who shall constitute another medical board who will give their opinion, and thereafter the magistrate must personally go to the hospital to visit that thing. So, what I am trying to justify, you see, just what legitimization of mercy killing. Right now, we do not have such a legislation which legitimize mercy killing or euthanasia in India. So, I have, you see, I have prepared this slide so that I can explain you the merits and demerits of this mercy killing. Clinical dead person and huge medical expenses, these are 2 important reasons for what? To legitimize this euthanasia. Clinical dead person, a person who is dead clinically, medically, there is no cure for, there is no, that disease is not curable in medical science, and huge medical expense is another important reason for the legitimization of euthanasia in India. But demerits of the legitimization of this euthanasia is, country like India, where people may take advantage of this, and due to greedy, due to even doctor may also sometime they may deviate from their desired behavior. So, I think the guidelines issued by Supreme Courts are sufficient to decide whether euthanasia should be, passive euthanasia should be allowed or not. This legitimization of this euthanasia would increase, would enhance problem of this issue. So, to in my understanding, Supreme Court has issued the guidelines for euthanasia, and that guidelines should be accepted, should be treated, because that guidelines is very good. Now, come to international position on euthanasia. What is the international position on this? So, you see the Netherlands and USA, UK, where euthanasia they have permitted this euthanasia, but in India passive mercy killing permitted. Passive euthanasia is permitted as per the guidelines. We have adopted this passive, not active euthanasia, as I said. And now, with the help of this slide, I want to explain that right to life or personal liberty, as you see in MS, the case where Bombay High Court for the first time in Maruti Sripati Dubbal versus State of Maharashtra, the question regarding right to life also include right to die was considered by Bombay High Court in this case, MS Maruti Sripati Dubbal versus State of Maharashtra. This is the first case where Bombay High Court held that right to life also include right to die. You see, law was not clear on this point, and when matter was brought into the notice of Bombay High Court held that right to life also include right to die. If a person who is suffering from mental disease, a person who is not willing to live in this holy world, he should not be compelled to live in all the adverse circumstances. But in Chinna Jagdishwar case, Andhra Pradesh High Court, you just can see on your screen, in Chinna Jagdishwar case, Chinna Jagdishwar versus State of Andhra Pradesh, AIR 1998, Andhra Pradesh High Court of that state held that no, right to life does not include right to die. Person should not be allowed. With the help of these two judgment of the high courts, I want to explain that even before P. Ratinam case, these are two important cases where both high courts had got opportunity to decide these cases, but in Chinna Jagdishwar case, Andhra Pradesh High Court did not accept the plea, and Andhra Pradesh High Court held that right to life does not include right to die. So, right to life does not include animal existence. As I said, Supreme Court has already highlighted that in Sunil Batra versus Delhi administration, Supreme Court held that right to life only means that right to live with human dignity, not right to live with animal existence. So, with this with observation of the high courts and Supreme Courts, I just want to make it clear that the law regarding there has been a long debate about legitimization of euthanasia in India, whether this should be legitimized or not, there should be. So, as I said, we do not have a special legislation on this point, which talks about or there is no statute in India which gives liberty to a person to finish his life. The only thing is that in case of passive euthanasia, medical board can decide whether a person should be given this liberty or not. So, these are few important judicial pronouncements through which I wanted to justify. Country like Netherlands, that is very small country where this law can be legitimized. This country, with country like India where multicultural society exists. So, legitimization of this euthanasia may create some problem. Apart from this, I would like to highlight this case. What I wanted to say in this Gyan Kaur case, you see this debate started in 1994 in Ratinam case, P. Ratnam vs. Union of India, IIR 1994, and but Supreme Court cleared the doubt in Gyan Kaur case, Gyan Kaur vs. State of Punjab, AIR 96, and held that this right to life only includes right to live with human dignity. Right to life does not include right to die, and persons should not be allowed to take away their lives. So, meaning thereby the philosophy enshrined in that judicial pronouncement which Supreme Court has delivered in Gyan Kaur vs. State of Punjab case, that the life of citizen is totally regulated by the state. You may have liberty, you may have certain liberty, but ultimately state will have to regulate the lives of its citizen. You do not have, means people, they do not have control over their lives. Though they are not the master of their life, they can decide their fate, but they cannot decide their choice to live or not to live. Not to live, that choice, the second choice is in the hands of state. State will decide whether you will have to live without any obstacle, without any restriction. You cannot take away your life. I can say that we people cannot use our liberty in that sense that I want to finish my life. So, state is the soul, or you can say the owner of life of its citizen. In that way we can use this word, that state will decide whether you will live or you will not live in this holy world, and no citizen. Country, very small countries have decided mercy killing or euthanasia, and many these words have been used in very different manners. You can say that mercy killing means doctor should be allowed to take away the lives of patient, and but we have adopted very precautive measures in India. Supreme Court has adopted very Supreme Court has been very cautious on this point, and so that this right cannot be misused or this procedure cannot be abused. So, that is why guidelines are very tough. There are very rigorous procedure to obtain a certificate from the competent authority to take the benefit or advantage of this euthanasia or mercy killing. The only way, the only situation where euthanasia, passive euthanasia is allowed in India, that is if medical board gives certificate that patient is suffering from acute disease, chronic disease. This is the first condition, that person must be, if person is of sound mind, if he is in healthy state of affairs, if he is healthy, then he cannot take advantage of. You all need to understand that even in Common Cause versus Union of India, AIR 2008, Supreme Court said right to die with dignity does not mean that every person has right to die with dignity whenever he wishes or she wishes. First is this decision is right to die with dignity, that is subject to two conditions. First is that person must be medically unfit, means that person must be suffering from incurable medical disease, and second thing is that board will have to certify that this disease cannot be cured and it would be better for the patient to take such a decision. So, this is two important limitations, or this is two important situations where euthanasia may be allowed. Otherwise, active euthanasia even still today is an offence. Abatement to suicide, or you can say a doctor may also be held guilty for assisting the killing of that patient. With this, I think you all have understood this euthanasia and mercy killing in the light of these two important pronouncement, Auna Shanbag case and common cause versus Union of India. You see, as I told you, common cause had highlighted this issue matter before Supreme Court in 2005 and the decision came in 2018. So, you can understand the gravity of this matter, how this matter was considered by Supreme Court. Supreme Court has issued guidelines, and after the compliance of this rigorous procedure, this euthanasia, passive euthanasia can be accepted, medical board can decide this thing. So, this is all about your right to die in peace, right to die with dignity. You see, this right to live, right to life is a human right. So, this has been a human right issues also. Humanitarian organizations at international level, they have been arguing that even right to be buried with decency, that is also a right of a deceased person. You might be knowing that there is a certain right which a deceased can also enjoy in legal system, though deceased person who is no more in this holy world, but even he, the deceased, is also entitled to be buried in decent manner, that you can't leave that body in open area, in open space. These are certain new things which have come after judicial intervention. Supreme Court has played important role in recognizing this right to die with dignity and peace, euthanasia and mercy killing, and social aspect I have already highlighted. Social aspect due to which this issue should not be legitimized, and this mercy killing should not be given to the statutory recognition in India. On the other hand, if I say that statutory recognition, statute must be there for passive euthanasia. So, each and every component of passive euthanasia must be clearly mentioned in that statute. If Parliament is willing to make special legislation on this point, having regard to paying due regard to the directives issued by Supreme Court. So, Parliament can do, Parliament can make such a law, but Parliament will have to follow, will have to comply the guidelines issued by the Supreme Court, and that guidelines must be followed by medical board step by step. I just want to explain that steps. The first step is that the application must be made either by patient. If patient is not in position to write an application, then the family member of that patient should be allowed to give application, should give their consent, and then after that application must be forwarded to the district magistrate. Third step, district magistrate will forward that application to the judicial magistrate. Judicial magistrate must visit that hospital where patient is admitted, and he should make a recommendation. Judicial magistrate should make a recommendation to the medical board that he has visited that hospital and that he has examined the patient or relatives of the patient, and patient or the relatives of the patient willing to avail this benefit, then only then the matter must be, this is the first step, last this is the fifth step, last step, only then matter must be referred to the medical board, and medical board, after considering all the relevant documents, may decide at what time, on which date that decision should be taken. In this way, passive euthanasia is permitted, and passive euthanasia is also beneficial not only for the patient who is admitted in the hospital, but it would also be beneficial for the family members who have lost their hopes about their patient, and they may lose their financial, all the financial or earnings in that medical treatment. So, in this way this process, this procedure may be legitimized by the statute. So, I have covered each and every aspect of mercy killing and euthanasia. I have also highlighted two important judicial pronouncement and role of Supreme Court, countries where euthanasia and mercy killing is permitted or not permitted, merits and demerits of legitimization of euthanasia in India. I have also highlighted that aspect, social aspect of mercy killing, country like India. Cases, there are 4 important case laws on this point: P. Ratnam case, Gyan Kaur case, Aruna Shanbhag case, and the last is a common cause versus Union of India. So, with this, I assuming that you all must have understood the things which I have discussed in this lecture, and with this I would like to conclude this lecture. Thank you all.
I am A.K. Sharma and I teach sociology at IIT Kanpur. I am going to address the question, what is the relevance of statistics in sociology? In India, there is some confusion about role of statistics in sociology, and most of the students of sociology suffer from what I call phobia of statistics. But actually, if you look at history of sociology or the kind of works that are being done in sociology or which are published in prestigious academic journals, you find that there is a lot of use of statistical methods, and not simple methods, very advanced methods. All of you know, as students of sociology, you know that one of the founding fathers of sociology, Comte, or another founding father, Emile Durkheim, they said that sociology is one subject which differs from other subjects in the questions that they try to answer, but they use the same method, the method of science. And that in sociology, those who believe in this kind of approach, they are called positivists. Emile Durkheim called them positivists. They believe that social issues must be studied by using observations, experiments, and other modes of collection of data. Now, statistics can help sociologists in 3 ways. Because if sociology is about social facts or patterns, not individuals, patterns of thinking, patterns of feeling, patterns of acting, behaving, and they can be measured, they can be quantified, and that explanation of one social fact can be given only in terms of other facts. We need statistics, because statistics can measure these facts, statistics can describe these facts. So, one branch of statistics, we can call it descriptive statistics, can help us in summarizing data, in measuring facts, like you are all familiar with simple statistical things like mean, mode, median, or methods of dispersion, standard deviation, range, variance. These are descriptive measures. They can also be used to measure skewness or symmetry or asymmetry in the data. Other types of statistical methods, which are called inferential statistics, are used to test hypotheses. We know that any science, including sociology, if we follow that positivistic tradition, is about testing hypotheses using scientific methods. And for testing hypotheses, like for comparative purposes, comparing means of two samples or comparing variances of two samples or comparing correlation coefficients or regression coefficients, we need inferential statistics. And if you are familiar with some of them, t-test, z-test, chi-square test, f-test, these are the tests which come under inferential statistics. We use statistics for drawing inferences about two or more samples. And thirdly, statistics can also be used for posing new questions. I remember that a few months ago I read an article in Population and Development Review in which the authors Cole and Gramajo, they tried to explain homicide rates and variations in homicide rates across countries in the entire world. And they found, based on statistical analysis, logistic regression and all, they found that one factor which explains variations in homicide rates in the world is female education, not culture, not governance so much, not even male education, but female education. Now, if facts are showing this, so you have a new sociological question: why is it that rise in female education leads to higher homicide rates? And Cole and Gramajo then gave certain hypotheses. You may not agree with those hypotheses, you may conduct this study on your own or test these hypotheses given by Cole and Gramajo using statistical methods. But the point I am making, that in addition to describing data, drawing inferences, statistical methods can also be used for raising new questions in sociology. And of course, you are all familiar that whenever the issue of prediction comes, predicting population of India, predicting urbanization, predicting per capita income of India 20 years from now, 50 years from now, there also statistical methods are of great help. And finally, statistical methods have been used in monitoring and evaluation of development policies run by various governments and NGOs. Thank you very much.